Welcome back. The assault version of accused number 2, Bongani Ntazi, is in the Meyiwa murder trial has been contradicted by a vehicle tracking expert evidence. Vehicle tracking records show that the police vehicle that transported Ntazi to Morocco police station in Soweto only stopped 3 kilometers away from where he claimed he was assaulted. Ntazi and accused number 1, Meyiwa, are challenging the admissibility of their confession, saying they were brutally assaulted by police into making the statements. For more analysis on developments in the Pretoria High Court, we are now joined by legal analyst Kabelo Seabi. Mr. Seabi, thank you so much for your time. It's always a pleasure to have you with us. Now, the trial within the trial continues in the Meyiwa murder trial, and the evidence presented in this week seems to not be in alignment with what the defense is trying to take us through in terms of a route.
Good evening, Katla. The evidence that has been led by the state, especially the scientific technical evidence of the vehicle tracking, is directly contradicting, and particularly the fact that the accused would have claimed that this vehicle stopped at dumping site where he was assaulted. It stopped at this steel pipe area where he was assaulted. Now, what the state has done in this trial within a trial, just to recap, is the following. They've led evidence that can be categorized into 4 segments. They have led evidence of the investigators, 2 of them who have testified so far, Sergeant Mokhane and Sergeant Mohola. We are awaiting the evidence of Brigadier Tininda. That segment of the evidence, these investigators have told the court under oath that there were no assaults and that the accused was not influenced in any manner in making the confession. If one takes that evidence and also the fact that that evidence to a certain degree is supported by the entries on the police records, the occurrence books, that evidence is very persuasive. Secondly, in the second segment, the state has led evidence of the scientific technical nature from the ABL. That seems to support the version of the state as well, that the vehicle never stopped at the places where the accused claimed they were assaulted. The third segment of the evidence that the state has led is the evidence of the Ekurhuleni Metropolis officers. Now, the evidence of those Ekurhuleni Metro officers would be looked at the court on the basis that they did not have any direct interest in the matter. They were merely making escort duties. And those Metro police officers have denied the version of the accused. The ace in the pack for the state is the 4th segment of the evidence, and this is the evidence of what would be categorized as the independent witnesses, the magistrate and the interpreter who were present when the confession was taken. These independent witnesses, both of them deny that the accused ever made any averment or allegation that he had been assaulted. And you must remember that these independent witnesses have nothing to gain from falsely stating evidence before the court. So the state has built a very formidable case with regard to these confessions.
I mean, Mr. Seabi, just to come in there, I mean, speaking of that, you made reference to the tracking, the car tracker that the state has put out. And in trying to prove whether torture took place or not by the defense, a lot of this car tracking evidence is being under scrutiny. But with so much time that has lapsed, I mean, it said that it's 3 kilometers away from where accused number 2 claims to have been tortured, and now that a mall or a shopping center has been built where he claims the assault had taken place, therefore the tracking device cannot say whether or not the stop had taken place there. With so much time that has gone by, can this evidence still be admissible in such a trial?
Yes, what the evidence would be looked at is the fact that the accused claims that the vehicle stopped at these particular places. Now, if the scientific evidence is looked at, and it must be looked not in isolation, but it must be looked at with the testimony of the investigating officers as well as the Metro Police who were doing escort duties. And if you take those 3 pieces of evidence from the investigating officers, the Metro Police, as well as the scientific, none of that supports the version of the accused. And that's why I said that the state has built a very formidable case. Obviously, one must not hurry to judge. One must wait until the accused themselves have been afforded the opportunity to put their version before the court. And once they have put their version before the court, all the evidence will then have to be evaluated. But on a prima facie or on a face value basis, the state has built a very formidable case for the admission of the confession.
Of course. Now, earlier in the week, Advocate Thulani Mngomezulu, who represents accused number 1 and 2, claimed that his clients were unlawfully arrested as they were apprehended for other crimes and then only investigated for the murder of Senzo Meyiwa after these arrests had taken place. What was your take on that?
Look, the evidence has revealed that the accused were arrested for several offenses. Now, some of these offenses they were charged with when they were already in detention. Technically, what it means is that when the accused is arrested for the first time, the accused should appear before court within 48 hours. Now, these periods of time were extended because the accused were arrested on other offenses. What Advocate Mngomezulu was contending was that every time the police interacted with the investigating team, let me correct that, the investigating team interacted with the accused. They were interacting with the accused based on the arrest on these other charges. And nowhere in the record does it say they were interacting with the accused with particular focus on the investigation into the death of Senzo Meyiwa. That is what Advocate Mngomezulu was contending.
Right.
The accused were being detained for offenses of drug dealing. They were being detained for offenses of possession of unlawful ammunition when they were when they were interacting with this investigating team. But the records nowhere show that the investigating team actually interacted them with particular focus on the investigation into the death of Senzo Meyiwa.
And based on that, would the defense not then have a leg to stand on?
Not necessarily. You must remember that the investigating team have said that when they were interacting with the accused then at some stage indicated that they want to come clean on regard with this other offense. And obviously, as I said, all the evidence would have to be scrutinized by the court once all the evidence has been led in the trial within a trial. The evidence of the prosecution and the evidence of the accused. The accused, you must remember, must still take the witness stand in order to give evidence under oath pertaining to the allegations of the assault. And obviously, when they do take the stand, they will be subjected to cross-examination, and their version will be tested by the prosecution.
I mean, you make mention of what Sergeant Mogola revealed, that accused number one had anticipated, or said that he had anticipated the day when he'd be held accountable for the former goalkeeper's murder. Now, this is for the first time in this trial within a trial that we get a glimpse of the contents of these confession statements.
The court at this stage, because it is dealing only with admissibility of the confessions, the court is not in a position to entertain the actual content of the statement. If you remember, when the magistrate was testifying, the magistrate only testified about the formal issues that would relate as to whether the evidence was freely and voluntarily. And also Colonel Rapadi. None of the people who took the confession straight into the merits of exactly what was said in the body of the confession, because that part will only become relevant once the court has determined that the confessions are admissible. If the confessions are ruled admissible, only at that stage will the state then recall the people who took the confession, and those people will then read into the record the actual content of the confession.
All right, Mr. Seabi, thank you so much for your time. It surely shows that this trial within a trial is nowhere nearing an end. As you say that within the 4 stages of the prosecutors, there's still that ace up their sleeve with the witnesses that are going to take the stand as independent witnesses. Thank you so much for your analysis.